Thank you, Chair, Counsel. Today we honor Gwendolyn Reese and John Wilson, two residents who have made an indelible impact on the Sunshine City. An impact that will reverberate not only in this time that we share, but throughout the time that fortunate people call this blessed burg home. Transcendent, they've helped write our community's inclusive history, stories that tell the truth and include too often excluded perspectives from all of the people of St. Pete. The impact of this gift of stewardship of our inclusive history exceeds the metrics by which we measure. Future residents will know who we were and who they are because of who these great residents are. Two people whose work and service make St. Pete a more complete, inclusive, and equitable community. And I'm excited to present each to you, but first, Mayor Kreisman, who could not be here today, will share a few words via video.
Good afternoon to all in attendance at today's City Council meeting, and a very special welcome to two special guests, my friends, Gwen Reese and John Wilson. Gwen and John, I'm sorry I'm unable to join you in person today, but I know that you're in good hands and that you'll receive considerable praise from those in the council chamber. The fact is, today's recognition is long overdue. Through your work and your words, both of you have given so much for so long to our city. You've told the stories of our people, past and present, in an impactful way. You've moved us closer to our vision of being a city that honors our past as we pursue our brightest future. And that's really what I admire the most. While you both love history, you are both forward-looking. And that's what St. Pete is all about. And so it's an honor for me to present you both with the key to the city and to thank you for
addressing the defendant's motion.
This is Mike Abel, Your Honor. I'll be taking lead on argument for the defendants on our motion this afternoon.
All right, Mr. Abel, feel free. I think we're set for about an hour, but if you all feel like you need more time, just let me know. Just to let you know, let me repeat, I have read everything. And not just your motions, I mean everything. I've read the complaint multiple times. I've read the attachments to the complaint. I've read the Constitution. I've read the statutes. I've read innumerable cases. So I just assumed everybody sort of get to their best points. Okay, Mr. Abel.
Your Honor, may it please the court, Mike Abel, along with Daniel Bean, Jacqueline Van Landingham, and Jared Burns, on behalf of defendants, Governor DeSantis, Commissioner Corcoran, the Florida Department of Education, the Florida Board of Education, we're here on our motion to dismiss. And thank you, Your Honor, for your comments regarding having read all of the materials. From that, the court is aware that the defendants asserted that plaintiff's complaint raises no justiciable issues. We assert plaintiffs lack standing. We claim that their claims present political questions beyond the purview of the judiciary. We contend that the remedies sought implicate the separation of powers. And Your Honor, these are threshold issues, as I indicated in our status conference. These are threshold issues that we believe the court must resolve.
Aren't lack of justiciable issue and political question one and the same?
Yes.
Okay.
Yes, and I think we've argued. I think we've briefed that as interchangeably, and I think I've argued that.
Okay, I understand.
Yeah. Your Honor, to your Honor's point, I'm not going to rehash our arguments in the brief. For our principal argument, then, Judge Cooper, I'd like to be able to respond to plaintiff's memorandum in opposition and show the court that nothing presented in that response should change the outcome. And in many respects, Your Honor, plaintiff's brief reinforces that dismissal with prejudice is warranted. Before I respond to their brief, Judge, overlaying all of this, I think two key issues bear repeating. The plaintiffs seek to enjoin enforcement of an executive order of the governor that merely directed state agencies to take some future action within their legal means to achieve a policy goal. The executive order, and the court indicated that Your Honor had read the exhibit to the complaint. The executive order itself, which is the subject of 5 of the 6 counts, does not itself impose any state action against the plaintiffs. And the actions that have been contemplated under that executive order have already been accomplished. Second, Your Honor, and I think maybe more importantly, in Florida Education Association, the case cited extensively in our brief, which I'm sure the court is very familiar with it at this point. We believe
The DeSantis versus FEA.
Yes, Your Honor.
I read that case about 5 times.
Right. Yes, and that's same here.
Yeah, and I'm familiar with that case anyway. It came out of the Second Circuit, so I'm familiar with cases coming out of our circuit.
Of course. Well, Judge, it's our position that this case is likely the most analogous case for this court to consider because it involved nearly an identical challenge, and that's whether a state level education policy violated Article 9, Section 1A by failing to provide a safe and secure schools.
So, Mr. Abel, does it have to do with similar facts?
Well, I mean, admittedly, Judge, that case addressed requiring schools to hold in-person classes, and the case before the court.
No, they didn't require that. As the First District pointed out, that executive order or that rule didn't require the schools to do anything. The district court pointed that out 2 or 3 times. It was a rule passed last summer, or I don't recall if it was a rule or an order, but it was an action taken.
Right.
In which normally, I'm going to give an example. These figures are not correct. They're used for example. But the state provides school districts compensation for students. The more students, the more state revenue the district gets. They provide a certain amount, let's just say hypothetically $100. Let's say $100 per day for students who are in brick and mortar schools. They provide less than that for students who are distance schooling, who are not in brick and mortar schools, let's say $60 a day. At that time, the state realized, I'm drawing from what the First District has said. These aren't my opinions, they're what I read from the First District. Is that the state realized that a vast number of people are not going to go to brick and mortar schools, and we're going to school from a distance. They realized that if the same rules were applied, the lower compensations for distance, that the school boards were going to take a pretty substantial financial hit. So they proposed to the school boards this: we will, for this year, increase the distance school reimbursement to be the same as the in-school. So everybody would get $100 per student. And that will obviate the financial loss you, the district, are going to take. However, for you to be able to receive this waiver of the rule, you have to have brick and mortar schools open, presumably for people who don't desire to educate their children at home because they don't think that was the best for their children, or they don't have sufficient child care, or their jobs don't permit them to have children at home, or for other reasons. So the school board did not say you have to do this. They didn't say if you don't do it, we're going to punish you. And so the First District said, it made a point that that was not a requirement to the school boards. The First District discussed a number of rules involving political cases, separation of power. They pointed out that political cases are really, I would call it separation of power by a different name, that they're subsumed into separation of power cases. They talked about the standard of whether it was arbitrary and capricious, I think. and several other issues. So that, as I understand, is the case there. The case here appears to be, from the complaint and from the memos, is that the governor decided that he was opposed to face mask mandates with no opt-out provisions. The executive order was written and that was then, there was a rule passed, Department of Health, an emergency rule, and the executive order tracked the Parents' Bill of Rights, which is, I'm sure everyone there knows better than me, is a statute that was passed in the last session of the legislature, went into effect, I think, July 1. So it seems to me that there are distinguishing facts between the two cases. Now, that doesn't mean that the law's any different. That doesn't mean that the result's any different. But they are two different cases, aren't they?
Yes, of course. I thought the court's summary is exactly as it was framed in the first DCA. I thought the court's brief summary of the initiation of the order, the reference to the Parents' Bill of Rights, that's correct. And I would agree that they're on a different factual basis. But I would respectfully submit, Judge, and we laid this out in our brief, and I'll continue to argue today, that those factual differences should probably have no impact on whether a policy provides for safe and secure schools amid a pandemic is non-justiciable. And I think that's
so
the overarching, first of all.
What is the policy that the governor or the defendants are expounding in this case? What policy are they saying is subject to political issue, separation of powers consideration?
Yeah, it's the preparation and implementation of the governor's executive order, which reflects a policy that would allow the Department of Health to direct the Department of Health to implement rules which would protect safety in the schools while protecting parental rights, as it's spelled out in Governor DeSantis's order. And then the Department of Health issued a specific emergency rule that attempted to protect parent rights and then lay out specific regulations with respect to safety in the schools.
Is the governor's order and the Department of Health rule, which was passed as a result of what appears to be the governor's directive, is the purpose of those to carry out this new law, the Parents' Bill of Rights law, as it relates to face masking in schools?
There's certainly, the governor certainly, in implementing that executive order, had the Parental Bill of Rights in mind. And this would be, the Parental Bill of Rights covers far more than just medical or health issues. But this is a broader, this would be subsumed under that policy and would be reflective of the policy articulated in the Parents' Bill of Rights.
Okay, so you said did you say the executive order doesn't do anything?
As with the respect to, it doesn't do any state action with respect to these plaintiffs, and that's the underpinning of our standing.
Does it say to the school districts where the plaintiffs have children that you can't pass a mask? Let me try to come up with a shorter phrase. A mask mandate, no opt-out provision. Doesn't it say that?
I don't believe it does, Your Honor. I believe it directs, and it specifically directs the Florida Department of Health and the Florida Department of Education working together to immediately execute rules that don't violate Floridians' constitutional freedoms, do not violate parents' rights under the Florida law to make healthcare decisions for their minor children, and protect children with disabilities or health conditions who would be harmed by certain protocols. It also states that, to Your Honor's good question from a moment ago, any action taken pursuant to the initial section should at a minimum be in accordance with Florida's Bill of Rights. And that was when I answered the court's question about whether this flowed from or was motivated by the parents' Bill of Rights. The governor put that specifically in his order. And then he directs the Florida Commissioner of Education to pursue all legal means available to ensure school districts adhere to Florida law, and continues from there. And so when I said I hope I didn't say it didn't do anything. It does. It certainly is
that
not.
may just be my Polk County phrase. That's what we would say in Polk County, but you probably said something more sophisticated than that.
I don't know if it was more sophisticated. I doubt it was more sophisticated, but it was the key point was that it did not direct any state action to these individual plaintiffs. And that was, as the court saw in our briefing, is the underpinning of our standing argument.
So let me read you something from the DOH rule that was passed as a result of this order, as I understand the complaint and the exhibits and the arguments. On the second page of it, it's where it says the full text of the emergency rule is, and it's 64 DER 21-12 1 D, and I'm quoting. Students may wear masks or facial coverings as a mitigation measure. However, the school must allow for a parent or legal guardian of the student to opt out the student from wearing a face covering or mask. So I'm trying to frame the issues in my mind. This is not indicated where one thing or the other. I'm just trying to make sure I understand the issues from the party standpoint. But it seems like that's ordering the school districts. It's telling the school districts you can pass a mask mandate, but you must allow an opt-out. Isn't that what that says?
I think that's a reasonable interpretation. And I also understand that that is the policy that virtually every school district in Florida is following, with the exception of, I believe, two.
Alachua and Broward? Correct.
And I believe the court
is Alachua and Broward.
Oh, thank you.
Okay. So there is actually well, tell me if I'm right or wrong. Does the executive order in the regulation then tell school districts you can institute a mask mandate, but you cannot institute a mask mandate that doesn't have an opt-out provision?
That would be I believe that would be a fair interpretation of the subsection D that Your Honor quoted. Okay.
So, and as I understand, again, I'm doing this from memory, so excuse me if I get the numbers right, but this, I'm conflating matters in my head, so I'll strike that and go forward. So as I understand, that's the only rule we have, is this one from the Department of Health. Is that correct? Or is there another rule?
The complaint, the operative complaint invokes the executive order, and it refers to this rule.
Okay. I looked for Department of Education. I'm not sure I found one there. I found this other one, Department of Health rule. So now when you say the executive order says you must comply with the law of Florida, and again, that's my own paraphrase, not exactly what you said. I think you said that one of the things the executive order does, and it's attached, as I recall, to the complaint, and it says, hold on, I'll find it. It says, Mr. Abel, I'm not a sophisticated lawyer, so I didn't draft a lot of documents that were full of whereases when I was a lawyer. So as I understand, the whereases are basically a way of saying, this is why I'm passing this order, or issuing this executive order. Is that the purpose for that?
I would agree that the preamble is to provide context and
Context for the order?
correct.
Okay, so the order itself is the part that says, now therefore I, Ron DeSantis, order the following things. That's the order, right?
Correct, Judge. I believe that's correct. Yes.
Okay, so that's like section 1 through 5. Section 1 says DOH and DOE should pass rules to make sure Florida's constitutional freedoms aren't violated. Why is it that we need a rule for that? Isn't that already the law?
Yeah, look, it's not a, it's a good observation. I believe that this was to reinforce the governor's very strong view that when these rules were implemented pursuant to his direction, I equated constitutional freedoms with the Parental Bill of Rights. I know the Parental Bill of Rights is part of the statute, but I also I believe that I believe the intent behind referring to constitutional freedoms is a broader notion of parental rights that was eventually manifested in the Parental Bill of Rights by the legislature. But to Your Honor's specific question, that's what I believe the intent behind that was.
I suspect you're probably correct on that, but as I understand the Parents' Bill of Rights, that's intended to codify into a statute the law of Florida as it relates to parental rights on areas that were mentioned in the law: education policy, health policy, which are two of the things mentioned, correct?
Among others, that's correct, Judge.
Okay. So, all right, we go from A, then we go to B. Don't violate parents' rights in the Florida law to make healthcare decisions for the children. That's Parental Bill of Rights too, isn't it?
I believe that that's what is intended by that comment, correct?
So like my dad used to say, if one's good, two's better.
Yes, I think that's right.
Okay, I understand. I was a lawyer before I got this job. I understand the idea of making sure that your points made clear in your documents. So we go to C, protect children with disabilities. I think that's explanatory. In section 2, it says, as a minimum, comply with the Bill of Rights. So that seems to also be saying, we've got the Parents' Bill of Rights. We want this complied with, right?
I believe that very much reflects the governor's intent. Correct.
Okay. So the Parents' Bill of Rights was passed by the legislature, right?
Correct.
And so it's the legislature that decides what's to put in that law, right?
Clearly.
I don't decide, right?
Our elected representatives.
The governor doesn't decide what to put in that law. That's the legislature, right?
Correct.
Okay. So 3 is pretty clear. 2. 3 is Commissioner of Education shall pursue all means available to ensure schools adhere to Florida law. So I think it means what that says. He wants the Commissioner of Education to make sure the law of Florida is followed. Right? Or am I missing something?
Those are clearly what the governor is intending by those words in section 3.
Is he referring there to the Parents' Bill of Rights again?
I believe that the governor in that phrase is referring to, it doesn't cite to them, it doesn't reference them, but I believe there would be other laws available that for enforcement beyond the Parent Bill of Rights that would be available to the Secretary of Education or to the Surgeon General in terms of ensuring that the school districts adhere to Florida law. So I don't know exactly, Judge, but I don't know that it's necessarily just limited to the Parent Bill of Rights.
Okay, I understand. Now, I have to be an expert on everything. So one of my law partners used to say my knowledge is a mile wide and an inch deep. So I've looked and I've been unable to find anything other than the Parents' Bill of Rights, and of course this order here that deals with face mask issues. Is there anything else? I just want to make sure that I know that if I need to look at something else, I'll look at it. As far as you know, Mr. Abel.
Right. As far as I know, I don't, but we're really just responding to the allegations and claims that have been asserted by the plaintiffs. I'm not trying to duck the court's question. I'm not aware of anything else.
I understand that. I appreciate that. So that's 3. And I do know under that section of that, or that chapter of law that the Parents' Bill of Rights is under 1014. There's a whole string of things. If you look at the top of that, it starts at like 1001 and then goes through 10, some more 10s.
Right.
And it says education at the top. So these are all different things that relate to education. I know it's not exclusive, but it seems to be limited to education, right? If you look at the statutes.
Yes, I've got, like the court, I've got a number of things around as well, and I'm trying to pull things as Your Honor was referring to them. And so I may not be looking at exactly what the court was referring to. And so I
totally understand.
Okay.
My question is, if you look at the enforcement part of the Bill of Rights, I didn't really see much in the section 1014.101 through 6. But what I saw later on down in that whole series of statutes at the bottom in the statute book appeared to be various ways to enforce everything that was included in that body of statutes referring to education. So I know that's not the clearest question in the world, but my question is that where the enforcement is for the Parents' Bill of Rights? Hold on a second and I'll let me see if I can get to that section. Let me pull my statutes up here. I go down to, it's called the Education Code. Starts with chapter 1000 and it goes through chapter 1013, and 14's at the bottom of that. And it seems like Chapter 1008 has something called assessment and accountability. Is that where the taking money away from school board comes from?
Correct, Your Honor. Okay,
that 1008.
Correct.
All
and
right.
When I mentioned into the courts, I was trying to find this, Your Honor, and I didn't mean to interrupt, Judge.
No, that's okay.
To the court's question from earlier about authority beyond the Parent Bill of Rights, the court citing the 1008.32, when the executive order referred to the Commissioner of Education pursuing all legal means available to ensure school districts adhere to Florida law, I did not believe it was strictly limited to the Parent Bill of Rights, and I believe the court has pulled and identified a source of enforcement under 1008.32.
Okay,
so I'm sorry, Judge. In fact, that's the exact, if I'm right. No, go ahead. I'm sorry, Your Honor.
All right, so I think I'm just trying to understand here. In a minute, I want you to finish your argument, but part of this is to help me understand some of these more technical issues from both sides. So Section 4 of the executive order, I don't know how many executive orders I've read, but it's not something I do as a hobby. So I don't know that I've ever seen this provision. This doesn't prohibit the legislature from meeting and passing some more laws. Is that a common thing in executive orders, or is that something unique to this one?
I don't know specifically, Your Honor. I will say that what this reflects is that the governor recognizes that the legislature are the representatives of the people, and that if the legislature was to meet to explore legislation to further protect the fundamental rights of students, that they would perfectly be free to do that. And this expressly acknowledges that.
Okay, I understand. So I had another question from your memo. Sorry, I'm jumping around a little bit, but
Please, Your Honor, please.
and then it says, let me see if I can find it. I made a note here and I'll find it. It says, I think I understand your position from your memo on page 3, that it's the governor's contention that his authority to have the agencies adopt rules is under Article 4, Section 1A of the Constitution. Am I reading your memo right on that?
You are, Your Honor.
Okay. And that's that thing that says he's got supreme executive authority and that he must enforce the laws, something like that?
Exactly correct, Judge.
Okay. So, and then I'm going down on something else on page 10, I'm sorry, page 5 of your memo. It argues that only the local school boards will have standing to argue that the executive order violates Article 9, Section 4. That's the provision that's been relied upon by the plaintiffs, stating that it's school boards are supposed to, the local school boards are supposed to run the schools. You indicate in your memo that the school board would only have standing, not the plaintiffs. Is that right?
Well, we believe the plaintiffs absolutely do not have standing. Whether the school boards do, they probably do, but they're not in this case.
You are aware of the First District case, School Board of Collier County versus FEA 279 Southern 3rd 281.
I am.
It's cited later in your memo.
I am, Your Honor.
You are aware that that was a case I handled, aren't you?
I may not have been, to be perfectly candid with the court.
You are aware that I took the position you just espoused about the school boards having standing to challenge a statute?
I'm pulling the case, Your Honor.
Yeah, well, so you won't have to pull it. I was reversed on that point. And under the, and I'm not arguing with it because the First District tells me what the law is. I don't do it the other way around. But they found that a school board doesn't have standing to challenge a law because a public official, or in this case, a school board, can't challenge the constitutionality of a statute that has statutory duties that govern the action of that state employee or state agency. There's a name for it, which I've forgotten, but it's a principle recognized. I've been reversed at least once on that, and that was one of the cases that's why I remember the cases I get reversed on, and for good reason, because I want to learn and do it right the next time. So I have to say, unless you figured something out that I haven't, I want to know why you think the school boards have authority to challenge this order.
Yeah, Judge, if that was the implication of our brief, then I didn't communicate that accurately. If the school boards don't have standing, then these plaintiffs absolutely are not going to have standing.
So does anyone have standing?
Not in this case. So
the plaintiffs say, this is their position. It's not my position. It's the plaintiff's position, if I can say it. They say, as I read their complaint in part, this is different from a year ago. A year ago, we had, I don't know what they call it, the type A COVID. And it was generally thought to be not very transmissible among children. And then say now it's different because of the Delta variant is transmissible. And I'm not going to say the word highly because I would wait to hear testimony whether it is, but I think they allege it's more transmissible between children than the other one, which I'm reading in between the lines, and I don't want to state for them what they're going to say, but I think they're saying that's one of the things that makes it different now than from what it was a year ago. But I am wondering, what is your response to that?
Two things. Number one, the legislature was aware of the new strains of COVID at the time of passing the Parents' Bill of Rights. The governor was aware of this when the executive order was entered. The Surgeon General was aware of this when the Department of Health rule was implemented. And so the risk factors, particularly when it comes to the governor's executive order and when it comes to the Department of Health's regulation, have been assessed, and determinations have been made that balance, in the view of the executive branch, safety and health and providing the best educational environment. Those determinations have been made. Now, so that's part one. Part two, as it relates to standing, as a legal matter, Your Honor, I don't believe that the increased risk factors of a strain of COVID change long settled standing law in Florida regarding standing and whether there is imminent harm, and whether it's last year's COVID or this year's COVID. We don't believe, defendants don't believe that changes or alters the assessment of damage or impact as the first prong of the standing analysis.
So if, by the way, I'm not ignoring the first district standing analysis in the DeSantis FEA case because they went through it in a lot of detail. But what I want to see if I can understand, is it the position of the defendants that saying that the schools can't pass a mask, no opt-out mandate, they cannot do that under any circumstance? I think that's what I'm hearing. Is that correct? They just can't do it.
Well, that would be inconsistent with the Department of Health rule that was followed by the government, that followed the governor's executive order. Okay,
so the plaintiffs are saying because of these new conditions on the ground, that's not reasonable, and they might use more technical terms. They might say that's arbitrary or there's no reasonable factual basis for that. So I'm not saying they're right or they're wrong. I'm not saying you're right or wrong, but under that scenario where children are catching COVID in the schools now, I think I can take judicial notice that is occurring. As I understand the defendant's position, there is no one who can challenge whether that policy is constitutional or not.
Just to specifically answer the court's question, I don't know that we've analyzed whether there is a plaintiff out there of some capacity that could challenge this. What we do know is that these plaintiffs, that parents lack standing for the reasons articulated in our brief. The court, and I appreciate this, Your Honor, we had written that perhaps the school boards have standing. Your Honor was adjudicated a case that held otherwise, and so I appreciated that. But I don't know that we've thought about who would have standing. Okay,
would a child in second grade who caught COVID and is in the hospital, would he or she have standing?
You know, I don't know, because I don't believe so, Your Honor, because of the other standing factors beyond injury. Okay, there's causation, and there's redressability. And so
Right.
even if there is a harm that's occurred, there still needs to be causation. There still needs to be redressability. And when it comes to this executive order, there's no link or connection between the order itself and an unfortunately a child who may have become infected with COVID, either at school or in some other place.
All right, thanks. So let me switch a little bit, Mr. Abel. This is for my education. Let's get away from the intermix between local school districts and the legislature has always been interesting to me, because it's never been clear to me where the dividing line is between the school board's ability to control and the legislature passing laws. For example, the plaintiffs say the school board has a right to control, but I know in one of the statutes I saw that I think was quoted as a basis for this order is 1002.33 or something like that? I mean, 1003.223. And this is what leads up to my question. That statute mandates that requires school children to get vaccinated for like 6 or 7 different things: polio, measles, mumps, a couple other things. So the state can do that, even though the Parents' Bill of Rights says the parents have the rights to make health decisions for kids.
I believe that I can pull it, but I believe it provides unless otherwise provided by law. And
okay.
So,
all right. Who makes, I don't know if we can settle today where that line is between local school boards and the state, but as far as the state's concerned, who in the state is in charge of legislating or governing the local school system? Is it the legislature or is it the governor? Who has that primary job that passes the laws? Now, we can talk about regulations in a minute, but who passes the statutes like 100322?
right. Well, for example, 1001.02, which establishes the general powers of the State Board of Education. That's passed by the Florida legislature.
Right.
1003.22, which Your Honor just cited, which, by the way, is the statute authorizing the emergency rule that's at issue before the court, issued by the Department of Health. That's also passed by the legislature.
That's the statute. I thought 12054 authorized emergency rule procedure.
Yes, that authorizes the emergency rule, but the specific authorization, the specific rulemaking authority for the notice of emergency rule 64 DER 2112 is 1003.22.
Oh, I thought it was the executive order. It's not the executive order?
It's not the executive order. It's the statute 1003.22.
So who's the head of the Department of Education now? Is that Mr. Corcoran?
Commissioner Corcoran, correct, Your Honor.
Okay. So from the defendant's standpoint, to the extent the state of Florida sets policy for schools, the legislature passes the bills. And then if there are rules and regulations passed, that's done by the Department of Education under a mandate from the legislature to pass rules to enforce the statute. Is that the way it works?
In part, but also the Commissioner Corcoran is an executive officer under the direct supervision of the governor.
Right. So what does that mean? I'm not sure I understand.
Well, that's another, if it would authorize the commissioner to issue rules pursuant to executive orders.
So the governor can tell Commissioner Corcoran to issue a rule?
Similar to the executive order that asked the Department of Education to work with the Department of Health to issue a rule pursuant to the executive order that's before the court.
Is there a statute that authorizes the governor to direct the commissioner to issue a rule? Or where does that power come from? Is it from the legislature?
Chapter 20, and I will cite to the court the exact.
Chapter 20. That's the chapter that sets up DOH as a department in DOE, right?
Actually, Your Honor, section Florida statute 20.02, subsection 3.
20.023. Administration of any executive branch department placed under the direct supervision of an officer or board pointing at or serving at the pleasure of the governor shall remain at all times under the constitutional executive authority of the governor, et cetera, et cetera. When was that passed?
This was passed following the decision of Wiley against Scott, which the plaintiffs cite in their brief.
So that's the Supreme Court case that said the governor can't suggest regulations.
Correct. And then the immediate.
So this was passed to avoid that.
Well, it wasn't passed. I mean, yes, but it's the legislature specifically abrogated the majority holding in Wiley against Scott. And the language that the court just read from 20.023 was the language that the legislature added following its decision to abrogate Wiley against Scott.
Has there been, I can check this later, but has there been any case interpretation of that statute that you know of?
Not that we know of, Your Honor. We have not found any.
Okay, so that answers that question. So then going on, I know, Mr. Gallagher, I know I'm going to give you equal time, but I'm just, it may be I don't have to ask you as many questions unless you differ on some of these answers Mr. Abel's been giving. But one, and I'll try to stop it with this, Mr. Abel, and if you have further, I'll be glad to hear your argument. But you said one thing that I wanted to ask you. I'm not sure what was meant there. Let me see if I can find it. I have a note on here. I think it was on page 17 of your memo. You say, and I'm quoting from your memo down at the last paragraph, quote, the executive order either precludes, okay, it says the plaintiffs have based their case on a fundamentally flawed premise. And you're saying the plaintiffs are wrong when they say the executive order precludes school boards from enacting mandatory mask or bans school boards from enacting mandatory masking. So when they say, I think what I'm hearing from the plaintiffs is they're saying, you have stopped us from doing this. We don't think that's constitutional. Are you saying the order hasn't stopped them from doing that?
I'm saying that that for the plaintiffs to claim that the order bans school boards from doing anything, whether it comes to enacting mandatory masking or banning school boards from enacting mandatory masking, no. Respectfully, we disagree. The executive order does not on its face do that. There's no state action to school boards on the face of this executive order. There's no.
Okay, so. Then is it the DOH order that does that? Or does any order not do? Is there any order that does that?
The DOH emergency rule, as it is what the court cited earlier in terms of what the operative emergency rule now is, and the court cited to subsection D, students may wear masks or facial coverings as a mitigation measure. However, the school must allow for a parent or legal guardian of the student to opt out the student from wearing a face covering or mask. That's the subject of the rule.
So you are, I don't think, the reason I'm asking you this question is when I first read it, I was wondering what I had been spending the last week reading for when you said it didn't require the schools to do anything. I think what I'm hearing you say, the executive order doesn't require it, but the Department of Health rule does not require it, but prohibit mandatory masking, no opt-out.
Well, yes, and to the point, and judges, again, we filed a motion to the complaint as it was filed. 5 of the counts are directed specifically toward the executive order. It asked this court to find the executive order unconstitutional. It asked this court to find that the executive order was arbitrary and capricious. It asked this court to enjoin enforcement of the executive order. There is one count that claims that the rule, the emergency rule from the Department of Health, violates the Constitution, and it is the same argument that schools should be safe and secure, and that this rule would cause them to be unconstitutional because it is not safe and secure. And so we focused a majority of our briefing and our argument to the way that the case was framed, and that was a frontal attack on the constitutionality of the executive order in 5 of the 6 counts.
Okay, so there's still something for me to do in this case then, because at least the Department of Health order does, as I read it, seems to say you can't do this thing that Alachua County and Broward County have done.
I'm sorry, but Judge, if you were asking me,
That's okay.
I don't know if I followed exactly.
Let me, when I say you can't do this thing is mandatory masking, no opt-out, which I have to be honest with you, I'm reading this from your memos and from the news media, not from the pleadings, but I don't think there's any dispute that Alachua County and Broward County are the 2 counties right now that are doing that, unless things have changed. But are you arguing that the Department of Health order does say to the school boards, you can't do what Alachua County and Broward County are doing? In other words, enact a mandatory mask requirement, no opt-out.
I don't believe that that's the full import. I don't believe that's a full, respectfully, Judge, I don't know that that's a full and accurate reading of the executive order. There are.
Tell me what it does say.
Well, there's other provisions that would then allow the department to assess what penalties could occur for noncompliance, and so the school boards can implement mask mandates, and there may be consequences. Okay, so I don't necessarily agree that it bans it, and that's the end of it. Okay.
Well, isn't that like saying, we're not telling you can't drive drunk, but if you do drive drunk, we're going to put you in jail?
I don't know that that's. I don't know that that's exactly. I don't know if that's the best analogy, but it's not. And by the way, it was the same thing in the Florida Education Association case. There were incentives for compliance, which were found to be perfectly reasonable. And so I don't know that
there was no penalty for noncompliance there. The noncompliance in that case was, we will enforce the Florida statutes and the rules as have always been enforced. There was no penalty for noncompliance in the DeSantis FEA case.
There were incentives for opening up schools live in order to obtain funding due to the decrease in school enrollment, and not be penalized because of students who chose to learn online. And I guess, Your Honor, I didn't mean to cut you off, Your Honor.
No, that's fine.
Okay. To Your Honor's last point that there's still something to do here. A majority of our brief focuses on political question. It focuses on separation of powers. And I would, to the court's point, I mean, the plaintiffs, absent this court dismissing the case, these plaintiffs, want to have a trial next week. Okay, and so if there's a trial, if the claims go, if a claim goes forward, first of all, we submit that all the claims are due to be dismissed, and they're due to be dismissed with prejudice. And the court, and there's sufficient support for that as articulated in our brief. And I do have some additional argument to make, although I know we've used up time for the plaintiff. But next week, and the court indicated that you would set aside 3 days. I mean, the court will hear from experts, and the court will hear widely differing views on masking in schools, the efficacy of masks in the transmission of disease, the efficacy of masks involving the social, emotional, and educational impacts of children where there's mandatory masking. There'll be widely differing expert opinions on that. The court will hear from parents who offer widely differing views on masking in schools and their sense of their rights and safety issues. The court will hear from policymakers. The court will hear possibly from students in the school systems. And then what happens? What happens at that point, Judge Cooper? I would submit that the court would be walking squarely into a non-justiciable political question. This is what we've framed in our brief. And the non-justiciable political question would be whether the executive order that you have asked us about and whether the emergency rule that you've asked us about implicate safe and secure public schools, and whether there's been a constitutional violation, and specifically Article 9, Section 1A. Now, we talked about it earlier, Judge, and we recognize that the factual underpinning was different. The first DCA did hold just last year that any judicial effort to evaluate the state's compliance with its constitutional and statutory requirements would violate Florida's strict requirement for the separation of powers. That's what the court held. And it also held that the terms safe and secure, as used in Article 9, Section 1A, lack judicially, and this is the key part for the court, lack judicially discoverable or manageable standards. And what the first DCA was saying is, and what it actually wrote, is that the court clearly saw the perils of judicial decision-making in this policy-laden arena. That's exactly what the court said. And so this was the largest subject of our brief. This is exactly why the political question doctrine and separation of powers are jurisdictional bars. They're not affirmative defenses, as the plaintiffs argued. That's not an accurate, that is not an accurate state of the law. This
Really?
Yes.
They sure look like affirmative defenses to me.
Your Honor, and we cited to the court Coalition for Adequacy and Fairness in Schools, Florida Supreme Court of Florida 680 Southern 2nd 400.
Yeah, that's the case that Circuit Judge George Reynolds ruled on, and it was affirmed by the DCA and went up to the Supreme Court. I'm familiar with that.
Right, and that was a case dismissed on a motion to dismiss because it raised a political question and would implicate the separation of powers. I mean, that case stands in the same.
I might have the case mixed up with a different one.
This was a 2000, excuse me, Your Honor, this is 680 Southern 2nd 400, and it's from 1996.
Okay, that's a different case than the one I just mentioned.
And it's cited in our brief, and it affirmed a trial court's decision to dismiss a case at the motion to dismiss stage because as the pleading was framed on the complaint, it supported dismissal because it raised a political question and involved the separation of powers.
So, Mr. Abel, how do you decide that the separation of powers applies?
You can look at the remedies that the plaintiffs are seeking and would involve, and this is what the first DCA was talking about in the DeSantis against Florida Education Association, when it was talking about the separation of powers. The trial court, in reference to separation of powers, the first DCA wrote that the trial court cannot grant their requested relief, which was an injunction enjoining enforcement of an emergency rule, without wading into the political thicket of education policy, emergency management, public health policy to determine what is necessary for the state to provide a safe and secure public school system. In addition, the first DCA held that the term safe and secure is used in Article 9 lack judicially discoverable or manageable standards, and wrote that any judicial effort to evaluate the state's compliance with those constitutional and statutory requirements would violate Florida's strict requirement for the separation of powers. And so when I was noting to the court what a trial would look like next week, what the court would hear, the type of testimony that the court would hear, which by the way, is not terribly different than the type of testimony the legislature might take when it's coming up with legislation and hears from citizens and hears from policymakers and hears from experts. That exactly what the first DCA was articulating in last year's case involving Governor DeSantis and this pandemic and safety issues involving the school is that the perils, the court was clearly warning that the intrusion of the judicial branch into this type of decision-making authority in an area heavily involving education policy, health policy, safety policy was would violate the separation of powers and were inherently political questions. And what the case from what the 1996 case, Coalition for Adequacy against Childs, held is that a motion to dismiss that raised political question issues and raised separation of powers on the face of the complaint itself was properly subject to dismissal on a motion to dismiss, was not an affirmative defense. And I would respectfully submit to the court here that as framed by this complaint, by the allegations of this complaint, what these plaintiffs have asserted is indistinguishable from Coalition for Adequacy, 680 Southern 2nd 400. And in terms of the legal work that the court would have to do, in terms of the legal rulings that the court would have to make, are indistinguishable from what the first DCA ruled in the case of the DeSantis Florida Education Association case we've been discussing this afternoon.
Okay, one last question for me, Mr. Abel. Looking at page 33 of your memo, which is towards the end.
Yes, Your Honor.
As I understand, it says neither the executive order nor the rule, that's the DOH rule, require that unvaccinated or non-maxed children attend school. It says, quote, rather they seek to ensure that school boards are complying with the Parents' Bill of Rights, leaving the decision of masking children to the children's parents. Does that, like a sentence, summarize what the position of the defendants are as to what the executive order and the rule are seeking to do?
That is an encapsulation of that. There are other, yes, to answer the court's question.
Okay. All right. So let me ask the court reporter, do you need a short break? Does anyone need a break before we go to the plaintiffs?
I would like 5 minutes just to use the restroom.
Okay. Let's take 5 or 10 minutes and we'll come back. And Mr. Gallagher, Mr. Abel has very professionally answered a lot of questions on details and procedures, which, unless you disagree, I'm probably not going to ask you the same question unless you think you have a different answer to those, or whoever's going to present from your side. I don't know if it's you or not, but we'll come back and hear from plaintiffs. Mr. Abel, thank you for, you were well prepared, and I could tell that you've read a lot of materials over the past few days. So Thank you very much. And we'll come back in 5 to 10 minutes. I'm going to leave the Zoom on. I'll just walk out of the office. Whoever, if there's anybody running YouTube, do not turn YouTube off. We're not done. And then we'll come back and hear the plaintiffs.
Very good,
Okay,
Your
so
Honor.
it's
Thank you.
I have it about 3:09 and I'll be back about 3:19, something like that. I won't start without anybody, so don't worry about that.
Thank you, Your Honor.
Thank
We'll take
you.
a brief break. The next one. Welcome back, everybody. Or I'm no, not welcome back. I just got back. So let me make sure everyone is here. We see the most important person, the court reporter.
Thank you.
And I see Mr. Dodson, Mr. Gallagher, Mr. Abel. There you are. Sorry, I mean, it rearranged on my screen a little bit. That's why I was searching for you. So who from the plaintiff wishes to make a presentation?
So I was going to offer some opening remarks, very brief, and we've divided up the different areas. So if your honor wants to hear from us all on standing and issues on the injunction and then political question and separation of powers, three of us have divided that up. But given that we are late in the hour, I'll just make a very brief opening statement. Again, Charles Gallagher here for the collective plaintiffs with co-counsel. It'll save time and not recite everyone's name. But yes, we are here to challenge the executive order and the rule pursuant to the 2 constitutional grounds in our memorandum of law. I won't belabor that point too much, but depending on what your honor wants to hear about, it might be one of the 3 of us discussing that
Okay.
reporting that issue. So,
All right. Well, I have read your order. I'm sorry, your memorandum with the same level that I read the defendant's memorandum. Mr. Abel did help me understand what I call some of the mechanics of this area of law, because executive orders, rules and regulations, things of that sort. I am in Tallahassee, but that it's as I'm sure the lawyers would agree, is kind of a narrow area of expertise. And as are the constitutional issues. So I'd be glad to hear whatever plaintiffs would like to offer.
so I think Mr. Wisenhunt will go ahead and begin a discussion on the standing issues.
Mr. Wisenhunt.
Good afternoon, Your Honor. So I think as we kind of go through the question of standing, which traditionally, again, would be raised more as an affirmative defense, but humoring the notion that it would be sufficient grounds here to dismiss, I think it's important for the court to consider there really isn't a question of lawful standing here. The historical perspective of any time a citizen of any state wants to challenge that a constitutional officer has exceeded the scope of their lawful authority is that standing is inherent directly from that there is an inherent harm in one of our elected officials exceeding their authority. And it's the position of the...
Mr. Wisenhunt, let me say, I'm sorry, Mr. Wisenhunt, but those who know me know that I can't resist not talking every now and then. So
Sure.
As I understand, as you just said, one of your arguments is that the defendants are exceeding the scope of their authority.
Yes, Your Honor.
Okay, go ahead. Be glad to hear you.
Sure. And so incumbent from that is the court is the place for redress of that question. It always has been. The courts have judicial review of what the other branches of government do to ensure that they are in compliance with the law. Otherwise, there would be no actual separation of powers, but power consolidated really to the governor to do as he so chooses. And then we would wind up in a position, much as Mr. Abel described, where the governor could do an act for which no one would have standing to challenge.
So I think I know the answer to this, and I suspect Mr. Abel would give the same answer you're going to give, but does any governmental officer, whether it be a judge, the body of the legislature, or an executive official like the governor, can they do anything they want to? And then it can't be challenged because of standing issue and separation of powers?
Of course not. There have to be limitations on government. That's how governments work. The citizens have given authority to the government to enact laws, enforce laws, interpret and apply laws. That's the functioning of a democracy and the backbone of a civilized society. But that comes with limitations. And when any member of that government exceeds the authority granted under the Constitution or by the law from the governed, when they go across that line, then the governed have a right to speak up and bring their concerns to the appropriate forum for redress. If a judge exceeds the authority, there's a means by which a judge can be impeached or recalled or removed from office.
Yeah, let's don't talk about that part very much.
But when the governor does it, the appropriate forum for any citizen to bring that concern is to the courts, where the courts can operate in an environment devoid of the false information and the barely admissible kind of ideas that float around on social media, but get to the actual crux of the matter, look at the law, and make decisions that are consistent with the framework that the legislature and the Constitution provide us. And in this instance, what we have is a governor who has grossly exceeded his authority. And in so doing, it created a domino effect. Well, Mr. Abel had referenced quite a few times that the executive order maybe didn't directly do anything. And then maybe the appropriate thing would be to challenge the Department of Health order. Well, if that were challenged, they would immediately turn and say, well, we gained our authority from the executive. We have the authority to do this the way we did it because the governor told us we could. And so we have to then go back a step and go, does he have the authority under these circumstances to do what he did? And it's the position of the plaintiffs that he does not.
So is this your standing argument?
This is, Your Honor. And so
Okay.
because we believe he exceeded his authority, we have immediate standing therefore.
Okay. So, Mr. Weisenhunt, I really did read the first district decision in DeSantis versus FEA. I don't want to use some other person's word, but that wasn't hyperbole. I really have read it probably 4 or 5 times. The first district laid out what I have in my notes is like a 3-element consideration for standing. Are you following the same general guideline the first district laid out in that case? Or do you have a different analysis of it?
So I think there's 2 ways to approach standing. And I think Your Honor is correct that FEA outlined, based upon the substance of that complaint, a 3-prong approach. I think separate and apart from that, though, standing can be derived other than through that 3-prong approach. Quite frankly, though, Your Honor, I believe the plaintiffs established standing through either approach.
Okay.
So if you look to the 3 prongs set forth in the first district's opinion in FEA, one of the first things that it addresses is there an injury in fact? And certainly there's an injury in fact here. We have children who are going into an environment that experts believe is potentially harmful to them. They're returning home and exposing their family members. They're having anxieties and mental health concerns that are derived from living in fear of being around people who are not following the best practices that experts are recommending. And moreover, they've lost their ability to bring those concerns back to their local school board, who is to be held accountable to them, because the local school board's hands have been effectively tied by the governor's order and the subsequent order from the Department of Health, prohibiting them from doing the things that they would otherwise do. Some of the school boards have boldly told the governor they don't care. They're going to do what is fundamentally right anyway, based upon the local facts on the ground. But other school districts are fearful. And you noted several times, Your Honor, earlier that in FEA, it wasn't a threat of harm. There wasn't a consequence. There wasn't a bad result. It was just business as usual if they didn't open their schools. Their funding would change, but not because they were being punished, but there was an incentive, the carrot versus the stick. And in this case, the governor is wielding his stick and threatening the school boards with a significant loss of funding, which will harm all of the students. The standing here, though, is parents are having to choose between a constitutional right their children have for a public school education, safely in their classroom with friends. And I think all of us would likely agree that in-person learning is preferred. In most circumstances, for most students, there's a derived benefit from being in the classroom. But no parent should have to weigh that benefit against the health and welfare of their child, with no opportunity to hold anyone accountable for that decision. You know, Governor DeSantis was not elected to be on the school board of any of the counties in Florida, and yet he's weighed in on a very local issue for all of them. He wasn't elected to be a member of the legislature, and yet he has weighed in and made a legislative policy that wasn't included in the statute. You know, if we look to 1014-04, the word mask never appears. And certainly the legislature could have put it in there if they wanted this specifically apply to masks, but they did not. And they didn't put anything in 1014 about public health. And I do think too, there is a very significant difference between a healthcare decision, whether or not to go to a doctor, which doctor, what medications perhaps to take, or what surgeries to have, and a public health decision. And nothing in the Parental Bill of Rights reserves to the parents the authority or the right to dictate public health for everyone. And masks are a question of public health, much as washing your hands is not a healthcare decision. much like gloves and hairnets for food preparation workers isn't a healthcare decision. This is a public health decision, and nothing in the Parental Bill of Rights intrudes on that. School boards have to be able to make public health decisions, and the governor, through his order, said, you know what? I don't think that it's reasonable or necessary or that it meets a compelling state interest. I'm going to issue an order saying that by my declaration, no masks. Even though the legislature didn't do that, even though no court ruled on it, nothing. And so the plaintiffs are now burdened by sending their children to school or keeping them home or losing the opportunity to go to magnet or charter programs, to lose that time with friends, or to be safe and healthy at home. And that is an actual cognizable injury in fact. The fact that they cannot hold their local school boards accountable to that is an actual cognitive fact that they've lost, effectively, in some ways, been disenfranchised by this decision because they've lost the ability to hold their school boards to meet the needs of their students. If the executive order were struck down, I know Mr. Abel has quite frequently pointed out, what would change? Well, quite a few things would change. Now, whether a local school district at that point proposes a mask ordinance or not, or a mask mandate or not, or has an opt-out or not, that's a school board decision. And the constituents of that school board can hold that school board accountable to it. That would be a change by rejecting this executive order. The ability for school boards to act independent of the threat of a loss of funding would be restored, which is an actual redress of the issue here. But right now, we're living in a state of more or less being hostages to an executive order that was issued at a time when we weren't under a declared state of emergency. The Department of Health issued an emergency order, but they didn't go through the normal rulemaking process. But they claim they had that authority from the governor. And the governor says, I have the authority because I'm the governor. And Mr. Abel says nobody has standing to challenge.
Mr. Weisnant, you mentioned something about the state of emergency, and I meant to ask Mr. Abel this question, but as I understand it, the state of emergency, did it expire at the end of June this year?
Yes, Your Honor.
Okay, I just want to make sure that some of these things, if they're not disputed, it'll save us some time if we get to trial. I haven't decided the motion because I haven't heard your complete argument and haven't considered anything Mr. Abel will say, but all right, thanks. Again, part of this is for you all to both, this far better than I do, is to help me understand the things that are probably not really disagreed on. In other words, in controversy. Sometimes we use legal words like whether it's in controversy or not. And for most people, it's whether or not you disagree on it. So I use my version of the word. All right, so sorry, I had to interrupt, but go ahead.
No, that's entirely all right, Your Honor. I think for the most part, that really does sum up our position for you on standing. We have this constitutional overreach, as we cited in our memorandum, Wiley v. Scott, which is a Supreme Court case from 2011, 79 Southern 3rd 702, which makes it very clear that any citizen has a right to bring a claim before a court for a determination as to whether or not a governor has exceeded their authority. So we have that version of standing, and then we also have the actual cognizable injury in fact, the causal relationship back to this order, and the redressability of what changes, and the ability to hold these school boards accountable, and the ability for school boards to independently make these decisions free from the extortive efforts of funding losses. One of the things that was raised before, and I know that you mentioned Your Honor had been overturned, as to whether or not a school board was the appropriate party for one of these actions. And I think Wiley v. Scott also affirmatively says that no, any citizen can be a valid party for one of these actions. I don't know that we would ever need a school board to join us, but I think we recognize that school boards have a vested interest in this because we can see at least those two and now several others that have pending actions to go against this governor's order. Clearly, they have a vested interest in it, and any citizen with any child in public schools in Florida has an interest in making sure local school boards can act in the best interest of local conditions for local students.
Let me ask this question. Mr. Weisenhunt, do you still contend that Wells Fargo versus Reeves supports your argument that lack of standing defense is an affirmative defense? That's a case you cited in your memo.
It is, Your Honor. And I think that is the traditional application for it. I think Mr. Abel's point that there are occasions where standing would be a suitable basis for a dismissal is true. For instance, I think if our plaintiffs entirely resided out of state, I think it would be sufficient grounds to dismiss the action because they don't have any connection to it. But I think
there
here
are certain
we're not
defenses like classic affirmative defenses like statute of limitations, which sometimes, in fact, I do agree with Mr. Abel. Sometimes you can take an affirmative defense and decide it on the face of the pleading because of the allegations. But I know this is not a scientific way to do it, but a lawyer I know who's still practicing in town, so I won't mention this lawyer's name, refers to affirmative defenses as yes, but defenses. And the way it's described to me is, yes, you say that, but I'm not liable because. That's what this lawyer calls it, yes, but, which is not highly technical, but I think a pretty good shorthand way of determining what an affirmative defense is or isn't. So I'll leave that to you for whatever it's worth. You feel free to use it. I'm sure this lawyer won't object if you use it in your own practice.
sure.
So,
I'm sure my students will enjoy hearing about it in our class next week.
yes, well, I don't know. Anyway, I've always felt that was a good, I find things like that are helpful for me to remember how to analyze sometimes very complex facts. So appreciate your comments. And so thanks a lot. And who's next, Mr. Gallagher?
Ms. Patelis is going to go ahead and brief the issue of injunction predicates, as that was one of the attacks on our complaint.
Ms. Patelis, welcome.
May it please the court, Your Honor. As Mr. Gallagher.
I have no easy ways to consider injunctions, Ms. Patelis, so I'll be glad to hear your thoughts on this. I do have a question for you, though.
Okay.
Let me go back to the complaint. Injunctions, what, count 6?
Yes, sir, it is.
Emergency injunctive relief. If hypothetically, I agreed with the plaintiffs on their declaratory judgment action, which we call it shorthand, we lawyers, DEC action. If I agreed with the plaintiff on that, would I even need to reach the injunction issue? Because many judges believe that if you order the state to do something or not to do something, there's no reason to put a mandamus order in or injunctive relief because the state or the state officer will do what is ordered unless and until it's overturned or modified later. So what's your thought on that?
Your Honor, my thought on that is if that relief is granted, it may render the injunction as a moot point at that point.
Okay, thank you.
Your Honor, with regard to count 6 of our injunctive relief, if you consider the motion to dismiss in the 4 corners of the complaint in the light most favorable to the plaintiffs, as Mr. Gallagher had mentioned, there are 4 predicates related to the finding of injunctive relief, specifically in section of Florida statutes 26.012 subsection 3. And in our complaint, specifically under count 6, we've alleged those 4 predicates. I know in the interest of time, Your Honor, I'm going to go through each of them briefly and individually.
Okay.
Thank you. The first predicate, irreparable harm. I'm going to try not to repeat everything that's in our brief, of course, again, in the interest of time, but the harm itself does not have to be incurred or guaranteed. In fact, there is a presumption of irreparable harm because safe schools are an entitlement provided by the Florida Constitution. In addition to that presumption, in our complaint, that irreparable harm can be established. Your Honor, we cite a few cases, including Leffervey versus Weiser. I hope I'm pronouncing that correctly. And Wintergreen versus Ware. These two cases discuss potential loss as loss of employees, an impact on a business, or a potential decline in property value. I believe that these two instances really pale in comparison to the irreparable harm that we allege in our complaint. The irreparable harm that exists and is alleged here, as we've been discussing, children catching COVID, children spreading COVID to parents, to staff, to family members, children getting sick and hospitalized, children dying of COVID. And what we also mention in our complaint, parents forced to withhold a child from school for safety purposes and losing placements, be that placements in magnet programs or placements in other schools. The second predicate, if you will, for the injunctive relief is no adequate remedy at law. Sir, specifically referring to page 23, line 193 of our complaint, the second sentence, this is not an issue that can be cured with money. Candidly, sir, it should say this isn't an issue that can be cured with a money judgment. No monetary compensation exists to remedy the irreparable harm that is being caused by the executive order as we speak. The third predicate, substantial likelihood of success on the merits, clear legal right. The Constitution entitles students to safe schools, and I know a lot of this argument is a little duplicative as far as the standing argument, and that power vests in the school boards. It's actually, Your Honor, in the DeSantis ruling as well as in the Constitution.
So you're referring to, hold on a second. Let's see if I can find that.
Your Honor, I've got it right in front of me.
I thought maybe what I have, oh, I've got my notes here. You're referring to the comment on page 1214 of the DeSantis decision.
Yes, sir. I think my page numbers may be a little bit different than yours. But yes,
yeah, what you're referring to is, quote, whatever the outcome of Appleby's lawsuit, the choice of how to deliver education to students remains with Florida school boards, end quote.
Correct.
How do we just, this is the issue I struggle with every time I see this issue in a case. How do we take that language and juxtapose, put it next to 1000, the provision in the Florida statutes that requires all school children in Florida to submit to 6 or 7 different vaccines that are in there. So is it that local control or is that something different?
Your Honor, I believe from the standpoint of vaccines and mandating vaccines, I honestly think that compared to what we're arguing today, it is something different. I think it's something that's established when we mandate the vaccines that we were talking about. I believe Your Honor went through the list of polio and so on and so forth.
Mm-hmm.
These are things that were established at a time when these were public health issues. And I do believe that as far as in this circumstance, when you're dealing with whether or not public health officials believe it's important in their own districts to reopen.
Yeah. So why would the legislature, I'm just looking, for example, 1003.06, classroom placement of multiple birth siblings. That seems very local to me. So how do we justify what the first district said in the DeSantis FBA case and what the legislature does? One argument could be that no one's challenged that statute, maybe. I know, here's what I do know. School boards can't challenge that statute. I do know that.
No, they can't.
So this is why I think it's confusing. I've done this for 45 years. And it's still kind of confusing to me. So that might be saying something about me, or it might be saying something about the issue. So help me with that.
Your Honor, and I don't think, honestly, I do understand the perspective of the court when it comes to that, certain issues, including the one about having siblings in the same classroom. I just think in this particular issue at this particular time, you have different variables, especially particularly to COVID, where you may have a school district that is experiencing higher levels of spread than you are in another area. And school districts need to be prepared for the safety of their particular students and their particular staff members to address these issues. Whereas in a circumstance, again, I mean, obviously, when the vaccines or when the issues are decided with the siblings, again, you may be right. It may be an issue that it never was challenged or never needed to be challenged. But in this particular issue, one county can be dealing with a different COVID spread than another county is dealing with a COVID spread, and having a general rule accompanying the entire state. It's not a one size fits all.
Yeah, it seems to me that face masks are much less intrusive of personal rights than having a needle stuck in your arm with a vaccine in it. So
Yes.
it's to me, it's still a question I'm pondering. I did note what the first district has said about this. I'm just trying to figure out where that line is, where that dividing line is. I don't know if my questions are helping any, but that's a question that I'm still trying to figure out.
And I think I understand where Your Honor is coming from with regard to that question. I do understand.
This is not a comment on the strength or weakness of either side's case, because at some point I may have to decide where that is. But that's something that I'm still thinking about. This whole issue with Article 9, Section 4B. This is not the first case I've seen that in. And so I've thought about this many times before. So I'll be thinking about it again.
Yes, sir.
But let me ask you, your case is not pinned on an alleged violation of Article 9, Section 4. There's multiple other factors in your case, aren't there? Or is this is not the only factor?
Yes, sir. That's not the only factor.
Okay, I understand.
Your Honor, the fourth and final predicate, if you will, for injunctive relief is public interest. I think looking at all counts within the complaint, including this count specifically, are for the benefit of public interest. The health, the safety of the public, and is in no way a disservice to the public interest, which again goes to vaccines mandated for schools and so on and so forth, as you and I were just discussing. Your Honor, with that statement with regard to count 6, I believe that if you look at the four corners of the document, the motion to dismiss should be denied. And I defer the remainder of my argument to Mr. Gallagher.
Okay, so Mr. Gallagher, is it your time?
Yes, Your Honor.
All right.
So I'll focus on political question and separation of power. And what I would say at the outset is, what can change in a year? I think that the defendants will have this court adopt FEA wholly and totally. And when you look at what's occurred from last year to this year in terms of COVID, the disease, and the external factors, there is a patent difference between the two situations. And I'm going to walk through a number of those situations factually that make FEA not line up on all fours with this case in terms of what was different. So back a year ago, we had a school reopening lawsuit. This issue here is more targeted and more narrow and more surgical in terms of banning masks mandates at the level of school districts. It's not about many weighty concerns of policy discussions and weighing all kinds of issues regarding reopening schools. This is a very targeted, narrow issue as opposed to last year's issue of reopening. How we get here? Last year it was a DOE order. This year it's a government, the governor's executive order. Now, last year when we had the school reopening discussion under FEA, that first DCA case took a lot of time to discuss how the school boards had some involvement in that. There were proposed reopening plans by the various school boards within the state of Florida that were part of that. They had a say in that, and they had some stake in that. Here, there is absolutely no involvement with the school boards. There is a fiat by the governor relative to this mask issue narrowly. Now, in the same evaluation that occurred last year in FEA, we had discussions in the case law about ensuring quality education and comprehensive well-being, very, very large, lofty, and broad concerns. Again, here, it is far more narrow in terms of the mask issue relative to the schools. The biggest issue of all factually, and Your Honor touched this at the outset, is COVID alpha versus COVID delta. As we have in the four corners of our complaint, there are transmissibility issues that are far more severe with delta. The viral load is 1,000 times that of alpha. And where we had last year's great beneficiary of saying that children were immune or children were spared, children are not spared. Right now, the numbers are belying any kind of argument that COVID Delta is not affecting kids, unlike last year where COVID Alpha was not quite as severe. The biggest issue we have also comes into the complex decision-making process that went into last year's reopening versus, again, this year, no school district was involved at all relative to the receiving this order that if you go ahead and have mask mandates, we're going to financially fine or deduct funding or whatever. I mean, you had involvement at the outset last year with FEA. You don't have it this year. One of the things that's concerning too is that last year there were multiple other options outside of in-person school. You had local virtual school for counties. This year, the one and only option is Florida virtual school, which is not by any means what you would expect in terms of a regular education type issue.
Is that not run by the counties? That's a statewide?
It's a state. Florida virtual schools is a state plan, correct, Your Honor, yes.
Okay.
And what the case law talked about, and not just FEA, but all the cases, is you have to have this policy choice and value determination predicate to come into a political question defense. And we don't have that here. We have here is operational overreach. We have a unified decision by fiat on the masks. We don't have stakeholders being involved and other kinds of background value determinations and policy choices that have been proven up. Now, last year, the language of FEA talked about the fact that medical standards were in flux. And how could you quantify what metrics would you use to see whether or not schools were safe? We are a year later. Currently, right now, there are numbers of metrics that are used as far as being able to evaluate what's safe, what's not safe for populations, for places, institutions, and schools. We have positivity ratings being used, which right now we are on a 20% range, okay? Meaning 1 out of every 5 people tested has COVID. We have an R0 issue, and that's the issue of what kind of transmissibility occurs. So for an R0 of a 6 or 7, which is right now, which is different than last year's 1 to 2, 6 to 8 people will be infected as opposed to that 1 to 2 last year. We have 10 times the cases for school-age kids than we did in 2020. So we have metrics that exist that a court can evaluate and see where there's a difference. And there is more uniformity, and certainly we expect to have a defense from the experts, but there's more uniformity in terms of the medical science and public health mandates on what is appropriate. What we didn't have last year, we didn't have any appropriate broad scholarly recommendations. There was no entity, there was no group that would tell us what we should be doing. This year we have two. We have CDC and American Academy of Pediatrics, with both counsel having mandatory masks in school for indoor school instruction.
So let me make sure I'm clear. For my benefit and anyone else who might be listening, the CDC is the Center for Disease Control, which is federal agency, which has been around as long as I've been alive, but deals with disease control.
Correct, Your Honor. Yes.
Okay. The American Pediatric or American Academy of Pediatrics?
Yes, Your Honor.
Is an organization of pediatric physicians who are basically children's doctors.
Absolutely. Society for Pediatricians to advocate.
Sort of in that specialty, it's like the American, there are a number of different organizations that doctors belong to. Orthopedic doctors belong to one, heart doctors belong to one, neurosurgeons probably belong to one. This is the one that's related to children's doctors.
That's correct, Your Honor.
Okay. All right, go ahead.
And the final issue, which was the most broad and most deep distinction between FEA and our case, is last year one of the prevailing concerns we had was over the populations that had economic disadvantage. We would have to reopen schools for free lunch programs. We'd have to reopen schools to have extended breakfast service for those in those same groups that are underprivileged. Here, and beyond that, we had economic concerns as well. As Your Honor so eloquently discussed, a per student allocation for on-site versus virtual was different. And you would have funding shortfalls if there was no reopening of schools. So you had a weighty policy choice and value determination that was employed and considered that had stakeholders other than just the governor. You had stakeholders that included the actual school districts who participated in their own reopening plans submitted to Tallahassee for approval. That is not the facts of this case. Here we have, again, by fiat, a decision of one person, the governor, on the issue of banning mandatory mask abilities for individual school districts, which is certainly, the case law is quite clear that they have the right to govern themselves. The Constitution gives them that right. So we have a very big distinction between FEA and our facts right now in this case. So that is the biggest concern we have on assuming or arguing or contending that there is some underlying extensive multi-stakeholder involvement where there were policy considerations, there was weighing of issues. That has not been borne out at all. And what's also very, very important here is that the one issue in the executive order where there's reference to the one and only Brown University study, right? Currently, that study has been recanted almost entirely. The authors of that study did not peer review it, and they also confirmed that they were not relying upon Delta data. So the one small scant bit of science, again, marginal, we presume, and we allege, was already undercut by virtue of the own study's author and the own study's sponsor.
So, Mr. Gallagher, in the complaint, in the order, I didn't see a citation of that, so I've not read that study. My assumption is that will be discussed by a witness or admitted into evidence or something along that lines.
Yes, Your Honor. It was part of the order, but yes, I'm going a little past the four corners. I apologize.
That's okay.
So
I understand what you're saying, but you know that is outside the scope of the four corners of the complaint.
The executive order does include the reference to the Brown study as underlying why it is a necessity medically. So it's referenced in the exhibit to the complaint. Now, the other issue to address is whether or not we meet or this case meets the Baker elements, okay? And there are a number of elements, and I'll go through those just point by point briefly. In the motion to dismiss, there's a very general averment that it applies, and without really going into the facts. So the number one element of the Baker test would be the issue raised has been demonstrably and textually committed to a coordinate political department, okay? So the idea of having or not having mandatory masking in schools has not been directed to any political department. Schools under the Constitution are the party who are entitled to govern themselves. That the case law is clear on that. There's a very nice quote from FEA on that exact issue we cite to in our papers. The second issue is that there are judicially discoverable and manageable standards for resolving the questions that are lacking. Okay. And so last year in FEA, we had a much broader issue being addressed. Okay. And it wasn't just safe schools. There were other issues as well to that effect. Here we have a narrow issue. And again, 1 year later, we have medical science that gives us metrics that are permissible, metrics that are available for a court to evaluate, to see whether or not comparing last year to this year, comparing this year presently, there is a safety issue regarding the schools where our youth are attending. So we have, again, positivity, R naught, percent rates, hospitalization rates. We have all kinds of different metrics that exist. So we don't have that element two of these standards that are not out there that are able to be used. The third element of the test is the court cannot decide the question without an initial policy determination of a kind clearly for non-judicial direction. We don't seek relief in this case to have any reforming or revision of that order. We seek to have the judicial overreach, the executive overreach in enacting this order checked and declared unconstitutional. We're not asking the court to go ahead and discuss whether or not the propriety of masking is fair, not fair. All we want to have is the individual school districts be able to have their own fate in their own hands. They can enact their own policies. So that's not not the relief we asked for here. The next element is the fourth element. The trial court cannot undertake independent resolution of the issue without expressing a lack of respect due coordinate branches of government. So again, the very vehicle we have for challenging an overreach issue would be the courts. The courts are going to help us out and check those overreaches and provide a remedy that will not let any one entity of government exceed their scope of authority. And I find a little bit of irony here in the fact that there's a defense for separation of powers when the underlying acts of a governor bring us here mount to that same separation of powers violation. So that there's no issue on the fourth element that would trigger any kind of entitlement under a political question. Under the fifth section, there is an unusual need for unquestioning adherence to political decisions already made. And again, the case law cited in our brief talks about the vehicle for challenging these issues is a deck action. We go ahead and seek a court's assistance in determining whether or not there has been a violation of the Constitution relative to whatever unchecked decision was made. And here it's clearly operational. There is nothing to support the prospect or the argument that there's some weighty policy decision making behind it. Nothing exists at all in that, specifically not the four corners. If we're going to address that argument at all, it definitely would be an issue that's affirmative defense. Nothing in the four corners talk about any concession of any kind of evaluation by the governor of those stakeholders. And the final element of this test, the Baker test, is number 6. There is a potential for embarrassment from multifarious pronouncements by various departments on one question. And this starts and stops at the constitutional entitlement to have school boards govern themselves. No other party has a stake in telling the school board what kind of masking enactments they can enact. This is not an issue for some other party within the government. This is an issue that is squarely at the feet of the school district. So there's not a point in time where we're going to have multiple decisions and conflicting decisions of maybe some legislative branch or some other branch. No, this is for the school boards and for the school boards only. So when you try to line up FEA in our case, they don't line up. Sure, there's a challenge to a government action from last year and this year, but that's where the similarities stop. Otherwise, we have vast, stark difference between the facts of our case and of FEA. I apologize. And so we can't go ahead and rely upon that. Now, again, we talked earlier about Wiley v. Scott, about that case where the governor's executive order was also remedied by this unchecked act of the governor was remedied.
Mr. Gallagher, Wiley v. Scott, 2011 Florida Supreme Court, adopted a 1981 Attorney General's opinion, talks about governor's power and legislative powers, etc. There is, Mr. Abel brought up chapter 20, again, this is from memory, 20.02, I think, 20.02, 3 or 4, something like that. It says there was an amendment after that. There's also a provision in Whitley v. Scott that says the fact that the governor can fire the head of the agency does not give the governor control of the agency. Now, I know the statute contains some additional language in there. Are there any cases that you know of that interpret that new statute, or do you have a position on that at this point? I might be asking you without you having a chance to research that. I don't know, but
We're talking about the Parental Bill of Rights.
this is where they say the Supreme Court case, the Whitley case. Hold on a second. I have it in my notes. And I'll quote to you what I think Mr. Abel is referring to. Let me put my glasses on. You know what? That's going to be, hold on a minute. Give me a second and I'll find it. Whitley says a number of things, and in the Attorney General opinion that the Whitley adopted says, here's the Attorney General opinion, it says the governor has no inherent powers, but possesses only those powers and duties vested in him by the Constitution and the statutes of the state. I don't think that's a controversial finding. And it says the thing I think that statute is amendment to the statute going to is this statement. This is in Whitley and in the AG opinion. Only the head of the department may, pursuant to the law, direct the powers, duties, and functions vested in a department or through designated administrative units, assistants, and deputies. And because the governor is not the head of any executive department, except for the executive office of the governor, he cannot, by executive order, give binding directions to any state executive departments created under Chapter 20, which includes Department of Education, Department of Health. The Supreme Court in Wiley v. Scott held that if the governor has the right to remove the agency head, that power is not analogous to the power of control. I'll translate that. It says it doesn't make any difference if he has the right to remove the agency head or not. So now Mr. Abel has cited to me a statute 20, is it 20.023, Mr. Abel?
Correct, Your Honor. Among other provisions that were amended by the statute.
That seeks to amend that, and they add in language that, Mr. Abel, I'm not looking at it, so I'm trying to remember it, that talks about on these agencies under Chapter 20 or certain agencies, the governor has the right to supervise and control those agencies or something to that effect. And help me if you see
right. May I judge? I know
yes.
It's Mr. Gallagher's argument. 20.02 subsection 3, the administration of any executive branch, department, or entity placed under the direct supervision of an officer or board appointed by and serving at the pleasure of the governor shall remain at all times under the constitutional executive authority of the governor in accordance with sections 1A and 6, Article 4 of the state constitution, and such officer or board generally remains subject to oversight, direction, and supervision by the governor.
So, Mr. Gallagher, I think Mr. Abel's argument is that language since the Wiley case changes that holding I mentioned to you on Wiley. Again, I may be catching you off guard. If you do, fine, but have you researched that? Do you have an opinion on that? This is a small nuanced area of the law. I recognize that, but it's not so nuanced that I didn't have a note on the case already noted in my notes. So
I will say that
I saw it, but I did not see what Mr. Abel pointed out.
Sure. I will say that when you obtain this case, there is no adverse history that states that is no longer good law or is modified by the statute. And of course, when we side check it, you're going to go ahead and find that out. So as we sit right now, I submit Wiley remains good law. And Wiley is probably the more analogous case to our facts here because of a rulemaking concern. And we talked about very early on the fact that this was enacted at a point in time where there was no state of emergency. June 27, that emergency ends. So the right to go ahead and have an emergency order from another division or another state agency is going to have attendant requirements to under the APA for those rulemaking concerns. Here, the Wiley case talked about this exact same issue, and this is why Wiley found the overreach to be an unconstitutional endeavor. Here, we don't have the required rulemaking predicates that are required under Florida law. The APA has not been complied with. There was no pending emergency that lets DOE or Department of Health have an emergency order in this fashion. There was not the appropriate notice period, question period. So I would say the short answer is I think that Wiley is still good law and stands for this proposition of law.
Okay, well, I don't know that the Wiley case or the change in Chapter 20 is determinative of the motion to dismiss, but I will tell you that because Mr. Abels pointed this out, I'm going to do more research on that, including trying to see if there's any staff analysis, which is my version of legislative history on this point. I don't know, maybe Mr. Abel has that already, but.
Your Honor, if I may, we do, and I can forward it to the court and to counsel, and the legislative notes make it crystal clear that the legislature was specifically abrogating the majority opinion, and plaintiffs, I'll wait for rebuttal, but plaintiffs have come into court arguing precedent that's basically been overruled. And so
I'm sure you are a follower of the late Justice Scalia and know that he did not hold legislative history in very high regard. And I think his reasoning is, I'm not a Scalia scholar by any means, but I think his rationale is you have to read whatever statute you're looking at. What's the phrase? Read it as written. You have to read it as written. And if you read it as written and it's clear, there's no need to look at legislative history. I'm not saying that's true or not true here. I look at legislative history, but I, first of all, try to see, is there a need to see it? Is the statute clear or not? Because legislative history, there was a very good judge here when I was just beginning to start practicing who used to refer to attorney general opinions as another lawyer's opinion. I think they're more than that, but I understand where this judge was coming from. And I do know legislative analysis is another person's opinion, but of value and worth. So you don't have to send it to me. I will look at it. If I can't find it, I'll mention it when and if we're all together again. I am kind of, Mr. Abel, to be honest with you, I am kind of getting into the weeds a little bit. So, but I appreciate the input of both sides on that point. So, Mr. Gallagher, let me turn it back over to you.
I'll try to be quick. I know the hour's late. So the next issue was one of separation of powers. And I said before, we are here because of exactly that issue, an overreach by the governor into areas that are not within his purview. So, and as you said before, I think it's accurate. Separation of powers and political question do very much merge and meld in their import. Here, obviously, the black letter rule of law is that a separation of powers defense is an affirmative defense. We cited a case on that. And the whole idea that you've stated too is the yes, but.
Yeah, that is Wolfinger versus Sentinel Communications is the case you cited on that.
It references that. It doesn't devote a lot of time to it, but it does reference the fact that the separation of powers amounts to an affirmative defense in that case. And I think that's important because the issue of, as you said before, yes, but, or we'll say it in a little more formal terms, but confession and avoid. So to assert those defenses, we have to go ahead and say,
that's the same. That's really the same thing as confession and avoid. It's just in real English.
You're right. You're absolutely right. And last year, there was no separation of powers attack that granted a motion to dismiss an FEA. That was not successful. One was made, yes. But here the question is, again, we're kind of retreading a little bit on evaluating the underlying action. And what happened in FEA and what happened here are very different beasts. There, again, we had stakeholders last year with multiple concerns, multiple issues where you had school boards involved. Here, school boards are left out of the equation. They were not part of the evaluation. They were not part of the policy making. They were not part of any kind of any part of the circle at all. So a very, very different place. Now, the two citizens cases, Citizens for Strong Schools, you have a perfect place to challenge these issues. There, they looked at the Bush case and looked at the voucher system that was an overreach or found to be an overreach. So again, here we're allowed to test that with a DEC action to see whether or not the governor's separation of powers violation amounts to a constitutional issue that would afford relief to our clients. So the concern here is that these cases talking about separation of powers entail and require lengthy blanket policy challenges. For example, in Citizens for Strong Schools, the 2017 case, this is a blanket challenge upon the whole entire public school program, whole public school system. And so we have issues that are deep and wide, and that's absolutely appropriate for the legislative branch and for policymakers who can go ahead and invest that time. But here, again, we are on a surgical, isolated, very limited issue of banning mask mandates in school districts as the issue. And so we are not looking at correlating issues from those cases to these cases. So here, in Citizens in the 2017 case, they were looking for the uniform, efficient, high-quality system of free public schools. That is a very amorphous issue. What we are here on today is not. We are here on a surgical, direct, small issue of the mask mandate. So neither Citizens case talked about school safety in terms of masks and in terms of what kind of harm was being avoided by this. And so we don't see there being any entitlement to separation of powers defenses here for those reasons. Again, the nature and scope of the underlying ask for the court, for lack of a better word, we're not asking the court to revisit these things and refashion some outcome. We're looking for relief that says this is unconstitutional and vacate that order. A far different cry from what they were asking the court in FEA and the Strong Schools cases is to go ahead and do a deeper dive into what really becomes a legislative function in policymaking. That is not the case here. We go ahead and are able to look at the factors from the Supreme Court under the Baker case, and none of them line up. We have a case that is very different in all respects, and we think that all these issues are appropriate to go past the motion to dismiss. We think the court should deny the motion to dismiss. If the court did grant it, we'd ask leave to amend, but we don't see that there being an appropriate corollary between those cases cited and our case here.
Thank you, Mr. Gallagher. Anything else from the plaintiffs?
No, Your Honor.
Mr. Abel, you want to have the last brief comments?
Sure, Your Honor. At the risk of overstaying our welcome, how long do we have to argue, Judge?
I don't know. It's like anything else. My definition of brief differs.
All right.
Depending on the circumstances.
Okay. Well, Judge, thank you for the opportunity.
Mr. Abel, I want you to be able to have enough time to state your position. So
thank you.
We'll take whatever time we need.
There's a lot to cover. There's a lot to work with in terms of issues to cover, but I think we'll focus on a few small, but let's say a few significant items that were presented in plaintiff's argument. Starting with Mr. Gallagher, who addressed the political questions. I think we conceded from the beginning of our argument, Your Honor, that there was the underlying facts of DeSantis against Florida Education Association from last year are not the same as they are here. But what the plaintiffs didn't articulate to the court in their argument directly relates to the binding precedent that the first DCA established and what it is specifically saying to this court. So Mr. Gallagher indicated that the court can evaluate the medical science, the court can look at the metrics, the court can look at the different expert testimony, the court can look at the efficacy of masks and whether it's helpful in spreading, in slowing the spread of COVID. and evaluate all of that, and that this could be a targeted endeavor. But no one answered the question or addressed the issue, which specifically goes to exactly what the first DCA was telling this court. The terms safe and secure, as used in Article 9, Section 1A, lack judicially discoverable or manageable standards. Any judicial effort to evaluate the state's compliance with those constitutional and statutory requirements would violate Florida's strict requirement for the separation of powers. And so the plaintiffs have just, they claim that they've narrowed the issue to something small and manageable, yet they nevertheless asked the court to do the exact same thing that the first DCA has said is beyond the purview of the judicial branch. The court also stated, and plaintiffs didn't address this in their argument to the court, that the analysis of the underlying case in DeSantis revealed the perils of judicial decision-making in this policy-laden area. In other words, what the first DCA was saying is that it's not the role of courts and judges to be second-guessing and questioning policy decisions that have been implemented in the executive branch. And no one from the plaintiffs addressed the other significant issue in DeSantis. Under separation of powers, the trial court cannot grant their requested relief without wading into the political thicket of education policy, emergency management, and public health policy to determine what is necessary for the state to provide a safe and secure public school system. But nevertheless, that's exactly what the plaintiffs are asking of this court, should we go to trial next week, to put your finger on the scale, to micromanage, to essentially make a legislative decision. And so no matter how they may characterize the facts being different or the dispute being smaller, it implicates the identical legal issues that were directly in play in DeSantis against FEA. And in their lengthy opinion, which the court is deeply familiar with, provides some very specific, and we would suggest binding precedent that would show that due to the political question, the separation of powers, this is not a justiciable controversy. And respectfully, not Mr. Gallagher and no one on the plaintiff's team provided any argument or any authority to the contrary.
How about Florida juror?
What was that, Your Honor?
How about Florida juror? Florida juror, there's a bunch of law in Florida, including the Florida juror constitutional law. State of Florida Department of Children and Families versus JB 154 Southern 3rd 479, 112 Southern 3rd 741 First District. They all say that acknowledge separation of powers. The judicial branch must not interfere with authorized discretionary functions of the legislative or executive branches absent a violation of constitutional or statutory rights. I haven't heard any evidence, so I don't know whether there's what the evidence will show one way or the other. So what do I do with that law?
Well,
it doesn't say you shall decide. There's no, it doesn't tell me, well, since another court has exercised separation of powers, that I don't have authority to look at the evidence.
Well, then what happens? And
I look at the evidence.
Right, and then, but the plaintiffs, but courts do more than just look at the evidence. Courts, the plaintiffs are here because the plaintiffs seek a ruling and they seek an order, and the order they seek is one that would, in their view, create a different policy outcome in Florida public schools as opposed to the one that the executive branch has established through its proper constitutionally countenanced authority.
Well, one of the things I tell, since I'm now not a young judge anymore, I don't know if you realize that, but one of the things I tell young judges, particularly those who do family law, is you should try to avoid trying to figure out what really happened. You should only try to determine what the evidence shows in your case and rule based on that. That's where I am here. I'll never know in any dispute, in any factual dispute, what, quote, really happened. I think that's for me to see what the evidence says, whether I think it meets the standards. I'm not saying that the first district in general doesn't in the case that you referenced doesn't in general state those principles of law. I think perhaps there might be other principles of law which weren't necessary for it to state that are also binding in this consideration. But again, that depends upon the evidence. So one thing I've already figured out is that I'm dealing with a really good group of lawyers who have done a good job at checking out the law and the facts in their case. And I have no doubt you will present concise, focused evidence in this case. And I will take in that to account. Some things may be based on evidence, some may be based on interpretation of statutes or something else. I don't know. But I don't want to I'm not saying I've decided. I just want to say that at some point after I've heard your arguments today, if we get past today, then I'd want to hear opening statements, then I'd want to hear the evidence, and then I'd want to hear your closing arguments. And then at some point, the ball shifts in directly into my court, Mr. Abel, as I know you know. And after I do what I do, then whatever the result is, it might be appealed. I'm fully aware and fully respect the First District's position and that of other district courts as well as the Supreme Court. I don't go around trying to think that I'm smart enough or have the power to make it up as I go. I really don't. I think you'll find that case that I got reversed on standing actually ruled that separation of powers precluded me from finding the statute unconstitutional. They just said there was no standing in that case. So, which doesn't mean I do that all the time, but that's just what that case held. Every case is different. And so I know there will be some evidence of some sort. I don't know what it is. I probably can assume there'll be some technical evidence of some sort. I don't know what other type of evidence there will be. I do look forward to hearing from the lawyers. You've held my attention very well for like 2.5 hours. And to hold my attention this well, you have to be a really good lawyer to do that. So both of you are good. You're doing it. And I can just say on the evidence part, I just have to wait on that. But I'm not ruling. I'm just saying that's where I am. In general, the First District discusses separation of powers, has many times. As you know, because we're in this seat of state government, the separation of powers issues comes up a lot. I think some of the lawyers locally have macros built in that say separation of powers in their word processors so they don't actually have to type it, because I see it all the time. It's a concept that's been around in Florida for 200 in the US for 200 plus years. I'm sure you all who are historians know this. It was discussed in the Federalist Papers. So, and it was discussed before the Federalist Papers were written in Europe, from which some of these concepts were taken. I just think that a lot of separation of powers depends upon an evidentiary consideration, which is kind of where I am. So, but I don't want to cut you off, but I want to let you know what these cases are that I found. I think what I said in these cases equally applies to political issues, political questions. Sometimes I'll look at things and wonder why they are this way. I think I understand the difference between political question and separation of powers, but everybody says political question is separation of powers. Why they're treated separately, I think political question is a narrower form of separation of powers. Maybe that's the reason they treat it that way, but I do think the same general principles apply to both. And so that's where I am on that. I just think those issues are trial issues.
with no indication, I don't know what evidence is going to be there. And I might say, well, Mr. Abel, that was a waste of my time, or I might not. I just don't know.
Your Honor, can I be heard on some of the other issues raised
Yes, you
by the
can.
plaintiff? Thank you. Thank you, Your Honor. The arguments as to standing covered by Mr. Wisenhunt. Your Honor, Mr. Wisenhunt somehow articulated that there's standing that comes out of Wiley against Scott, that it confirms standing on the plaintiffs in this case. There's not, I respectfully submit, and I know the court didn't want to hear more argument on Wiley against Scott, but nothing in
I
Wiley
understand.
against Scott.
Well, that argument was new to me, so I haven't really totally digested it, Mr. Abel, on the Wiley versus Scott issue.
And moreover, Mr. Wisenhunt ignored, he talked about actual harm and articulated, an argument that plaintiffs could overcome actual harm, but ignored the other two factors that go to standing. He didn't argue that there was a causal connection between the injury and the conduct complained of. He didn't argue that the plaintiff must show a substantial likelihood the requested relief will remedy the alleged injury in fact. Plaintiffs acknowledge in their own brief at page 21, Your Honor, that even if this court were to strike the executive order, what plaintiffs say in their own brief, although striking the executive order would not instantly provide mandatory masking mandates, it would give plaintiffs the ability to hold their school boards to account to science and local conditions without the extortive influence of a loss of funding. It's a pejorative sort of characterization, but it's essentially a concession that even if this court were to hold that the rule or the order was unconstitutional, that it wouldn't provide the plaintiffs the relief that they are attempting to secure. And so for there to be to the court's comment about your lawyer friend who says, yes, but. And that
person might be famous after this case is over, right?
Yeah. The yes but lawyer. But I guess I would have a response to the yes but lawyer. We don't get to yes but in this case because we've talked about jurisdictional defenses, and as standing has been presented to the court here, standing is a jurisdictional issue, a threshold issue that these plaintiffs have to overcome before that they are able to come into court and to present evidence. Now, I will, I would want to cite to the court Solaris against City of Miami. This is reported at 166 Southern 3rd, 887.
887.
166 Southern 3rd, 887.
Give me a second and I'll pull that up. Let me just make a note here. While I'm doing that, am I correct that 3 other counties have passed mask mandate with opt-out only for medical excuses?
I believe that's correct.
Hillsborough, Palm Beach, Miami-Dade.
That's correct.
Again, that's for context. That's 6 1 half a dozen as far as the issues in this case. But let me go to Westlaw.
Yeah.
Westlaw, hold on a second. I'll get to it.
Your Honor, the context for our argument on standing here is that there are numerous cases that find standing to be a threshold issue that must be determined before reaching the merits. Solaris is one of those cases. Jones against Department of Revenue from the first DCA is one of those cases. That's reported at 523 Southern 2nd, 1211. And McCarty against Myers from the first DCA, 125 Southern 3rd, 333. Standing presents a threshold inquiry that must be made at the commencement of the case. It is well established that a party seeking adjudication of the courts on the constitutionality of statutes is required to show that the constitutional rights have been abrogated or threatened by the provisions of the challenged act. This plaintiffs cited to the court in the brief 5 or 6 cases that use the label affirmative defense when it came to standing, the yes, but characterization of standing that Your Honor was referring to earlier. And all those cases were mortgage foreclosure cases where the standing issue basically comes down to, is the note holder the actual plaintiff in the case? And in that context, I can see where it appropriately might be evaluated as a standing issue. But if we can put the labels aside of affirmative defense and focus on the legal attributes, what we are showing the court is that for the court to proceed to trial, it must be presented with a justiciable case or controversy between parties who have standing. That's what the Solaris case said. What we have shown in our brief and what we have argued to the court is that the executive order, and plaintiffs didn't discuss this part in their response. They didn't discuss, Mr. Wisenhunt didn't bring this up in his discussion. He focused on actual harm. He didn't focus on causal connection between the executive order and the hypothetical injury. And I think the court understands this, and I think we've been through this, but on a critical threshold issue such as this, the executive order, again, doesn't direct the plaintiffs to do or not do anything. The executive order doesn't direct the school districts to do or not do anything. There's no causal connection between the executive order, which simply directs the Department of Health in conjunction with the Department of Education to issue rules to protect students and parents' rights. That's the beginning and the end of this. And Mr. Wisenhunt, I hope I'm not butchering your name, Craig,
butchering the argument a little bit, but you got my name spot on.
Well, yeah, I mean, but your argument said that Mr.
1 out of 2 is not
never,
bad, Mr. Abel.
What was that?
1 out of 2 is not bad. You got his name right.
Redressability was not addressed. The relief requested will remedy the injury in fact. Plaintiffs, I pointed out that the plaintiffs are essentially conceding that the remedy they seek of mandatory masking in schools is not something that's going to be achieved even if the executive order is removed. And so I would respectfully ask the court to focus, and I know you will, Judge, and you've given us nearly 3 hours this afternoon on a significant case and with significant issues. But the cases we've cited to the court on standing are jurisdictional and would create, there needs to be a case or controversy for this court to hear next week, okay? Or else the court is just giving an advisory opinion about the court's, the constitutionality of an executive order and a rule, both of which were appropriately enacted pursuant to Florida Constitution and Florida law. And so the plaintiffs, they can't plead, I heard, and it was in their brief, and I heard today, let us amend our complaint. Well, they could have amended their complaint before this hearing today. But now the complaint is what it is, and we've argued. And so if the plaintiffs are unable to replead to create standing, and therefore, Your Honor, when they lack standing, there is no case or controversy, and this case is due to be dismissed. And I would, and we can send, it looks like the court has copies of these cases, but
I have them all.
Okay, the standing issue that we're talking, this is far different than standing in a mortgage foreclosure case, where you just want to make sure that the note holder is the plaintiff. Okay, this is a
Oh, I've probably done 2,000 foreclosure hearings.
right.
Yeah, I'm familiar with all that law.
Okay, all right. And so here we don't get to yes, but because this is standing is being presented as a jurisdictional defense, and the absence of standing would lead to a finding that there is no case or controversy, and that this would simply result in the court giving an advisory opinion. Plaintiffs have not presented an argument as to the second 2 factors of standing. Plaintiffs have not established that in the complaint, the operative complaint that's before the court. And that's fatal to their case. And I would respectfully submit, Your Honor, that this case is due to be dismissed because these plaintiffs lack standing and because of the nature of the executive order and the limited scope and the limited impact that it has. And I know the court focused on this. We went through the executive order and its reach very, very specifically. 5 of the 6 counts deal with the executive order. That is what they're asking this court to hold as unconstitutional. That's what they're asking this court to find, that the governor exceeded his executive authority. Now, we believe those claims are baseless, and we have elaborated in our brief the legal principles, which the plaintiffs really haven't attacked, other than citing Wiley, as to the legal basis for both the executive order and the rule that followed. But 5 of the 6 counts deal with an executive order that has no direct impact on these plaintiffs. That's where we started at the very beginning of this argument a few hours ago. And unless these plaintiffs are able to establish, which they can't, it can't be pled around. It's not a fixable problem. It's not an amendable complaint. Then this complaint's due to be dismissed with prejudice. And we respectfully submit, Your Honor, that is the outcome based on the pleading as it stands and the state of Florida law and the status of that executive order with its limited reach.
Okay, give me 5 minutes. I'll be back in 5 minutes. Let the court reporter rest her hands for a little bit, and then I'm going to give you a ruling. Okay. 5 minutes to 5. That's when I'll be back, Eastern time. I'll leave the Zoom on, the camera, so I'll be right back.
All right, court reporter ready?
Yes.
All right, let me make sure everybody is, looks like Mr. Gallagher, Mr. Abel, everybody's here. So let me say this for everybody who may be watching. Lawyers know this, but I don't make up the law. I don't sit at home saying, what should the law be? I try to figure out what it is. I've read the first district opinion in the DeSantis case last year. It states a lot of general principles of separation of powers, et cetera. There are differences in facts in the case. However, I don't know all the facts because I haven't heard the evidence yet. Respectfully, I do find that standing has been sufficiently pled. There may be more evidence that'll support standing at trial, but I think all the three elements of standing is set forth in the test in the DeSantis case has been met. I know in the other case from a year ago, the court noted the emergency order in question did not require any teacher, staff member, or student to return to the classroom. Here, the plaintiffs are bringing this action individually for themselves and their children. They contend, and again, I'm not ruling that they're right or that they're wrong. They contend the governor's order and the Department of Health regulation prohibits the use of masking mandates with no option out except probably for medical reasons in accordance with the CDC guidelines, American Academy of Pediatrics. They allege, as I understand their complaint and their arguments today, that will submit the parents and their children to increased and unnecessary risk of contracting COVID. The children, because the Delta variant is more contagious to them. How much so? We'll have to see what the evidence shows, but I'm talking about the allegations now. The parents, because if children catch it, if they have a higher likelihood of catching it, the parents have a higher likelihood of being exposed to it. And the parents have a right to have, of these children, these plaintiffs have a right to have some input into their children's decisions, just like parents do everywhere. In particular, children that are too young to be vaccinated, which I think includes some of these children, as I understand, is under 12. I'm not sure if it's 12 or under 12, but I think their standing is in part based on the allegations of this case is that they will be subjected to an additional uncalled for risk of COVID infection because of the mask mandate issue. They contend that the elimination of impediments to masking mandates would lessen the risk of infection for them and inferentially for their parents. And to have standing, as I've read in the first district opinions, the plaintiff must have a personal stake in the outcome of this proceeding, such as an injury that may be redressed by the suit. And I just believe under the standards set forth by the courts that I'm required to follow that element has been met at this time. I do think standing can also be considered an affirmative defense. So there may be more evidence that will affect this determination at another time. And if brought up, I may be required to rule on standing again after all the evidence is in. The second element of standing is the plaintiffs must establish a causal connection between the injury and the conduct complained of.
The DeSantis versus FEA case found that the plaintiffs there did not meet their burden because the state's conduct caused them no injury. The court in DeSantis says we are not making them do anything. In that case, the children weren't forced to return to classrooms by the state. Here, I think what I heard at argument is the ability to this school distance is more limited now than then. There are, just like there were a year ago, there are parents who, because of work or other arrangements, actually cannot, even if distancing is available, cannot do that. They must send their kids to school. Plus, if children can't go to the classroom because there's no masking mandate, and they believe that submits them no masking mandate of the sort that's at issue in this case. And they believe that that prohibits them from going to the classroom. Thus, it would deprive them of the, I think the consensus is the best education is the education you get in the classroom. And they can't do that because they would be subjected potentially to an increased risk of COVID if their school board's not allowed to institute safety plans that the school board requests that might be consistent with state law, but for the governor's order. Again, I'm not saying I agree with this analysis. I'm not saying I disagree. I'm saying this is what I think is the clear intent of the plaintiff's allegations and argument. Therefore, the second element's been met. 3, the final element of standing is that plaintiff must show a substantial likelihood that the requested relief will remedy the alleged injury in fact. The injury is subjecting children, vaccinated or not, but primarily non-vaccinated children, because, as I think pointed out in the complaint and the argument, if you're vaccinated, there is a line of defense against COVID that does not include masking. It's the vaccine. If you're not vaccinated and you are in a class that can catch it, which the allegation is this COVID variant includes children, then without masking, distancing, other things, you're deprived. If you can't go to the full element of masking, you're deprived. So the plaintiffs argued, subject to proof in this case, you're deprived of a ability to protect yourself against COVID infection, in particular for younger unvaccinated children. The injury is requiring the parents, in part, is requiring their parents to expose their children and through their children and conduct school in a less safe way than the schools would choose to do. I believe that the last element of standing is met. Again, this does not indicate that I've decided anything because I haven't heard the evidence, which is one of the reasons it's a very high risk venture for a trial judge who does not want to be reversed to decide these issues on a motion to dismiss, because the reversal rate among judges who do that is very high. I do think that the parents and the children have standing. They have the right to contest the governor's and the Department of Health's actions in this case as alleged. They seek to have their rights heard. They seek to have the school boards and the governor and the DOH to comply with the law of Florida. They contend the law of Florida is not being complied with. So this is a case where I find the law and the allegations and presentations does support standing. These parents and children, they have a right to have their case heard in court. That's what I'm deciding. I'm not, again, let me underscore. I'm not deciding that they win or they lose. I'm just deciding they have the right to have their case heard. So on the other issues, separation of powers and political discussion, I think those are in part factually driven defenses. I don't think they can be decided at this point on a motion to dismiss, certainly not with prejudice. I do think there are separation of powers doctrine, which includes the political discussion or political issue. It's not just that the court can never rule that any action by a state actor is unconstitutional. That's not the law. It should not be an everyday occurrence. In the first district sets forth parts of the law, but separation of powers has several exceptions to that doctrine, one of which is separation of powers don't work if the law is unconstitutional or violates some other law, or if that action is that way. Again, I'm not ruling that's the case. I'm saying that's the allegations. That's what's been argued. And I just think that deserves an evidentiary hearing. So I do think Mr. Abel and his people who have worked with him have prepared an excellent motion and memorandum. They've done a very good argument. I put him through the grill on questioning. His ability to engage in a Socratic dialogue is very good. Likewise with the plaintiffs, 3 lawyers who presented, they all also prepared excellent memoranda. They answered questions well. Both sides have brought up points which will merit further consideration once we get into the trial mode. But this case should be tried and a record made. And then we'll see where we are at the end of that. Mr. Abel, Mr. Gallagher, Ms. Patelis, Mr. Weisenhunt, thank you for the rest of you. I appreciate you all being here. I have no doubt you all, there was time enough to hear from everyone. Everyone else who didn't talk would have had something very valuable to say. But I could say this, that I can't promise you anything other than I will devote every ounce of my energy to be prepared to read whatever you present, to read the cases you cite, to consider your positions, and do the best I can do. That's what I promise you. Other than that, I can't make a promise, but I can promise you I'll do the best that I possibly can do. And then after I'm done, it'll be up to someone else to look at it. I do have one issue I want to raise with you. I don't want to discuss the nature of it because that person's not here, but let me go get a motion I just got when I walked outside. Hold on a second. Someone else. Yes, I received today on about 4:30 today, an email with an attached notion of appearance of it says notice of appearance by Elvin Dowling and motion to intervene signed by attorney Barry Silver. I don't want to discuss the details of it. Mr. Silver may be listening, but it seems to me that what we should do is notice this for a hearing 9:30 Monday morning so that I can hear the issues. You all can have a chance to, let me look online and see if this is filed yet. Hold on. Let me pull up my viewer. don't see it being filed, but in this motion is indicating that that Ms. Dowling has filed a related case in Broward County. And you all can write this down if you don't already have it, but it's 21 CA 5339. If you want a copy of this, I can have my office my judicial assistant is left for the day. So I'm operating one-man show here, but I can have this forwarded. I can have her scan it and just forward it to you so you can see it. What I would like to request is the plaintiffs' counsel just do a notice of hearing on this motion to intervene. And Mr. Silver's BARRYSILVER. He's in Boca Raton. And I will, his address is here. I'll just have my judicial assistant scan it and send it to counsel records so y'all can do that. I would ask defense counsel, I think here's my case management order. Y'all are going to file an answer tomorrow, is that right?
Correct, Your Honor.
Let's see. Answers by tomorrow. So when you do get it, just be like y'all have done already, email to Ms. Barber. That'll be good. And if it's possible, if you can send me your exhibits in some sort of, I don't know how extensive they'll be, but in some sort of binder form. If you don't mind, I'll do one of two things at your request. I'll either not look at them until we start the trial, or I'll read them over the weekend so I'll be familiar with them. So it's your call. Either way's fine with me. Do y'all have a preference one way or the other?
Logistically, to get you a binder for the weekend tomorrow, even if we did it like on an airplane.
Well, you could, if you can't get here, how many pages are we talking about? This, or what?
I guess maybe 2-inch, 3-inch, pages, nothing, no banker's boxes of documents, no.
You could scan them, send them to my judicial assistant, and we have a big printer here. She can print them, and I have spare binders. I can put them in a binder. Mr. Abel, do you have a preference one way or the other?
Your Honor, I don't believe we have extensive exhibits. We probably can send those as an imaged copy to the court, and we have no objection if the court begins to review the records in advance of the evidentiary hearing.
All right. Mr. Gallagher, do plaintiffs have any objection?
No objection either. No.
Okay, so do y'all want me to have these exhibits to be in the format that if you wish to admit them, I can make them the original court exhibits?
I think that would be
Good time, yeah.
If you do, I will resist the urge to write on them.
Oh,
I won't write on them. I don't have to write on them. I can put Post-it notes on them.
Or we can send two versions. Send a pre-marked version with exhibit stickers and then another version for your marking up.
It's your call. Whatever works easiest for you. I'll be working all day tomorrow. I'll be working this weekend. And I will see you all Monday, 9:30. We'll take up the motion to intervene at that point. I want to the reason I'm raising it now, I wanted to let you know as soon as I knew about it. And then we'll decide that issue. Then we'll go forward with the evidence. I'll let you all pretty much set your time records how you wish to do. But what I'd like to do is y'all figure out a way that each side get kind of an equal division of time. You have 3 days. You're not required to use them, but if you do, you can. I was sort of thinking that if you use the full 3 days, what I would like to do is after you've made your closing arguments, come back the next day on Thursday, maybe in the afternoon, and give you my ruling, probably in a form of a speaking ruling. It won't be, you can't just take it down and put it in an order, whatever it is, but it'll give you, I think, a good idea where I am. And if you want to have the court reporter do an expedited transcript of that, you can get that and probably write an order from that, whichever side is writing the order. The reason I'm doing that is that gets you the quickest way you can get a decision. If I write it, it will take longer because of just the crush of things I have going on. So that's sort of I usually do that. This is not an unusual procedure just for this case. My normal procedure is to give you a verbal ruling and let the lawyers, write that down in more precise order form. So do y'all have any questions or anything?
Your Honor.
All right. Again, I want to say that I think the lawyers on all sides did a very good job. Their clients have made good choices in choosing them. Everybody very professional with each other, with me, very well prepared. And so I look forward to seeing you all Monday morning, 9:30. So we will be on Zoom, but the rest of anyone who wants to watch it can get on the Second Circuit website and click the little thing up in the right-hand corner. I think that's where it is. It says YouTube, and they can watch it on YouTube. So I think this went well today. Do y'all have anything else you need to bring up?
I think we're good, Your Honor.
Nothing from the defendants, Your Honor.
All right. Thank you very much. We'll see you all Monday morning.
Thank you, Your Honor. All the best.
Okay.